Picture this. Your buyer or seller is under contract, and the closing attorney's office calls and says there's an issue with title. Or, boy and girl loved each other very much. They didn't get married. Now the romance is dead, and one person doesn't want to sell the house. Or great-granddaddy bought 100 acres of land in 1917, and it's just been passed down through the family. My cousins and I want to split it up or sell it. Or my neighbor is claiming that my fence is on their property, but that fence has been there for 30 years. Now what? The classic lawyer answer is always, it depends. I'm here to give you the CliffsNotes version of 3 types of litigation cases that come up most often: heirs property, partition, and quiet title. The heirs property type of litigation is pretty much exactly what it sounds like. In our scenario about Granddaddy and his 100 acres, we would file a case asking the court to determine who are the heirs of Granddaddy and to determine the percentage of the property, or profit, to which each heir may be entitled, and to ask the court to order that the property be partitioned. In the case of the 100 acres, one option would be to seek a partition in kind, which means the property is literally subdivided amongst the heirs. In most instances, it's impossible to divide real property fairly and equitably. How do you go about dividing a single-family home? Usually the court will order the property to be sold, which means each heir gets their appropriate share of the proceeds. In an heirs property case, the heirs get first dibs to buy out the other heirs at fair market value or at a court-appointed price. Otherwise, the property will be sold on the open market, which is what we try to obtain that order which allows that. If the judge will not allow us to sell it on the open market, or if it won't sell on the open market, then it can go up for judicial auction. Once the property is sold, the closing cost, the cost of the partition action, and any necessary judgments or liens will be paid off first. Then, whatever proceeds are left will be divided among the heirs. Sometimes, however, in a case like Granddaddy's land, one person has been taking care of the land for 10 or more years, and they want the court to decide that the land is theirs and not the heirs. This would be a case for adverse possession. And that dispute between the neighbors about the fence line? This is a case for adverse possession too. Adverse possession means one person has exercised control over the land belonging to another for a period of 10 years or more, in a manner that is open, notorious, and hostile to the actual ownership rights. These cases are very fact-specific, and you need to work with an attorney who has experience litigating those issues. Partition litigation is an action between co-owners who cannot agree on how to use the property. For example, the family court will take jurisdiction over the marital home, joint assets, and joint debts. But what if the house isn't marital because there was no marriage? Or what if you co-own the house with a family member or a business partner and y'all can't agree on how to manage the house or whether or how to sell it? If one co-owner is seeking to sell a home and the other co-owner is seeking to keep it, the only reasonable approach would be either for the co-owner seeking to keep the home to buy out the other owner's interest in the home, or for the home to be sold and the proceeds from the sale to be divided equally between the co-owners. But people will get stuck on what is a fair buyout fee. While it is always in the best interest of co-owners to reach an agreement independent of the court, since partition actions can get costly, when an agreement cannot be reached, forcing the sale of jointly owned property through a partition action may be the only option for the co-owners seeking to terminate their interest in the property. Have you acquired a great deal on a piece of property from a tax sale? Or the closing attorney discovered a tax deed in the chain of title? What about the discovery that the seller only owns a 1/2 undivided interest in the property? In these situations, a quiet title action can clear up the title and confirm the ownership in the property. A quiet title action asks the court to review the history of the property and make an order that clears the competing claims against the property, even when those competing claims are just couched in old deeds or documents. Quiet title actions include heirs property actions, boundary disputes, and adverse possession, or can resolve unsatisfied liens, gaps in the chain of ownership, and easement disputes, just to name a few issues. If you are fixing a technical title defect and there is not a true dispute of ownership, then you will likely obtain a judgment by default, which means nobody came to court and tried to dispute your claims. However, if you are dealing with a true dispute over ownership, then the action will be contested. In this case, the case proceeds through the court like any other litigation would: discovery, mediation, and trial if no settlement is reached. When dealing with real estate and dirt litigation, it is important that you use an attorney that not only understands how to review title, but also understands how to litigate cases in the South Carolina courts. If you have any questions about a quiet title or any other real estate needs, please do not hesitate to reach out. At DGR, we look forward to helping you.